Further hearing in the appeal Four Seasons Holdings Incorporated against Brownlie.
Yes, Mr. Ross.
Lady, could I start by indicating my client is present today? Lady, the structure that I was hoping to adopt was as follows. To start with the issue of standard of proof in relation to the jurisdiction gateway and to a lesser extent the merits test, because that may be common ground between us. Secondly, the issue of where the contract was concluded. Thirdly, the requirements necessary to establish damage within the jurisdiction gateway in tort. The fourth issue will be dealt with by my learned friend, Mr. Chapman, who will be dealing with the issue of the claimant's pleaded case, whether the reference to the Acts, the Fatal Accidents Act and the Law Reform Miscellaneous Provisions Act, confines the claims to damage recoverable under those acts.
I think it would be a good idea if you spoke up a bit, and I'm not sure that the microphones are...
And the microphones are on.
You just switched it on.
You've just switched it off.
Oh. But one way or another,
Hoping to improve matters.
I'm fairly sure that the people at the back of the court can't hear you.
Right, very well.
I didn't entirely follow this last point. Perhaps you could...
The last point is the claim is pleaded under the Fatal Accidents Act and the Law Reform Miscellaneous Provisions Act, which would be standard for a claim brought in this jurisdiction. Defendants, as we understand it, are taking the point that that doesn't have extraterritorial effect.
What about the question whether the first defendant is the party that should be sued?
I had endeavoured to deal with that on the last occasion, and
But something, a certain amount has happened since then.
a certain amount has happened since then. I'm obviously prepared to deal with it if needs be, but as matters stand, it appears that there's a great deal that's still in the air at the moment. We still haven't had disclosure of documentation. There are a lot of factual disputes pertaining to that. And the question arises whether this tribunal is an appropriate tribunal to resolve those matters.
You don't normally...
Or whether, yes.
You don't normally get a pre-trial discovery, not at any rate without a special order.
Indeed.
What has happened is that the hide-and-seek game,
Yes.
which was being played by Four Seasons for a long time before
Yes.
May, has now come to an end.
Yes.
And it's pretty clear who was running this hotel. Now, you say that you want to deal with, for example, the question where the contract was made. Why is that a sensible thing to be decided if wherever the contract was made, it was made with the wrong party?
Yes. My Lord, my understanding from the last occasion, and I may be quite wrong in this, was that this court might have had in mind that that would be an issue involving a question of fact and also a question of an application for substitution, and that therefore this court would not regard itself as being the appropriate forum in which to resolve that, and that the court may have had it in mind to transfer that down to a trial judge who could resolve the issues of fact, bearing in mind what we would say that the disclosure exercise still hasn't been completed, in the sense that we know now, belatedly, only in the Supreme Court, part heard, that it's now contended that contrary to the public documentation from Bloomberg, which suggested that the appointment of Mr. Masson was by Four Seasons Holdings Incorporated, the current defendant, that they are now contending in their last statement to this court, but not substantiated by any underlying documents, that appointment was in fact made by Four Seasons Hotels Limited. The question next arises...
What matters is who was running the business with who, and whose business was it with whom Lady Brownlie contracted. And that, with respect, now seems abundantly clear, and documentation has been provided which makes it clear.
Yes, well, my Lord, your Lordships know that that was an issue which we were reluctant that the court should go into, bearing in mind that it was being done at Supreme Court level, because that put us at an enormous disadvantage. Are we to make an application to this court now for it to allow a substitution? I'd need to take instructions on that.
Well, one possibility would be that the appeal might need to be allowed on the basis that you have sued the wrong party, but that instead of striking the case out, I raise this only as a possibility, the matter then be remitted to the High Court for your client to make such applications as regards other parties as she may be advised to make.
Well, can I be straight with the court? It was our intention, bearing in mind that the defendant's stance hitherto, as your lordship said, play hide and seek in relation to this, but hinting at the fact that it was not the correct party that we had sued, but refusing to tell us who it might be, was to deal with the jurisdiction point in the way in which it was dealt with by the courts below, namely for the court to draw inferences from the limited evidence that was available for the court, and to conclude that that did establish a reasonably arguable case against Four Seasons Holdings Incorporated. There would then be an application to substitute the correct party if it transpired on disclosure that the correct party was somebody other than the current defendant. Now, we have been bounced, to use the vernacular, partway through this hearing with evidence in relation to which we have not seen the underlying documentation, which would substantiate Mr. Masson's appointment, and more particularly whether Four Seasons, it now seems Hotels Limited, was in fact controlling his activities and the way in which he ran the hotel in Cairo, which would entitle us on that basis to continue to have a claim against Four Seasons Holdings Limited. There's further complicating...
Why is that? Just explain what claim, what Mr. Masson has got to do with it.
Mr. Masson is the general manager who is running it.
Yes.
The hotel. He says he was we're told now belatedly that he was a director of Four Seasons LLC. There are a number of agreements which indicate that he was in place to as the link between the Four Seasons hotel companies, which had an interest in the way in which the hotel was being operated and the way in which the hotel was being managed. In particular, who was it whose idea it was that this hotel should run safari excursions?
Why does that matter? The contract wasn't made with Mr. Masson, it was made with the concierge. And the question is, who was the concierge acting for?
We don't know anything about the concierge at the moment.
We know that the concierge must have been employed by the operating company that operated this hotel on behalf of Park. We know that from the documents that have been disclosed by Miss Henderson.
Well, my lord,
Mr. Masson doesn't come into it.
Well, Mr. Masson is a link between... It appears that he was the regional manager as well. And he, on the basis of the documentation that we had, he was appointed by Four Seasons Holdings Incorporated. That may or may not be right.
What's the legal conclusion you draw from that? That the contract was made with the holding company?
No, that the holding company may have controlled the activities and had an involvement in the activities of the hotel in Egypt through its officers and representatives, which obviously would include Mr. Masson as the general manager of the hotel.
So do you conclude from that the holding company is what, liable in tort for everything that goes wrong at the hotel? Is that
no, it depends on the element of control that's exercised. And for example, in relation to this particular safari, there was, as the court now knows, the Luxor massacre that took place. There would have been a review of whether or not the tours could continue and in what shape or form. And our expectation is that the Four Seasons companies further up the line had a very real involvement and say in relation to the way in which the tours were going to be operated thereafter. And it's that involvement that we haven't yet had an opportunity to explore in any way, shape or form. And to say that we are at this juncture, full discovery not having taken place, no opportunity to ask or get answers to requests for further information, that we are bound to sue one company only, in my respectful submission, is an inappropriate way for this court to proceed. Much preferable would be to allow this issue to be transferred to a trial judge to resolve, because if it's resolved only on the basis of the documentation that's been produced.
When you say this issue, what precisely do you mean by this issue?
Which is the correct contracting party and whether or not we're entitled to substitute. What your lordships also don't know is what the Egyptian law in relation to limitation is, or prescription as they would call it. Because if it transpires, and we believe this may well be the case, that the limitation period hasn't expired in Egypt, then there's no problem about adding a party to these proceedings, and we don't even need to substitute. Now, your lordships know nothing about that issue at all. Well, it's only arisen because of the disclosure that was made partway through this hearing, which suggested that the only indications that we've been given hitherto that Four Seasons Holding Incorporated was the party that was issuing this brochure, and that was sufficient for our purposes to establish that this was an agency relationship that was taking place here, that they had authorized the use of their brochure and that all roads led back to 1165 Leslie Street. That might not be correct. So to say that we can't substitute now that this issue has arisen would be to perpetrate a grave injustice in our
nobody is, I think, suggesting that we should say that you can't substitute. You seem very likely to be right that you don't need to substitute anyway, either in English or Egyptian law, because the fact is that because of the silly games that Four Seasons had been playing for months beforehand, you are in a strong position to say that you did not know the relevant facts necessary to bring the action against the right party until a very late stage.
Well, in our respectful position, then it would be better to have that issue decided.
I'm beginning to think it'd be better to have all the issues go back, to have the case to be sent back to a judge to determine this. The trouble is, if we determine some of the issues,
yes,
they won't be in proceedings to which probably the critical party may not be a party now, because whatever you say, it doesn't look very likely, at any rate to me, that the holding company is very likely to be liable. But somewhere else down the line, very probably...
It may be hotels and
I mean, what surely should happen is that you should get your tackle in order as regards the parties, have a hearing before the High Court, at which all the potential parties against whom there is a real case will be present. That may well involve getting a new order ex parte for leave to serve out on additional parties. That would mean that we would have to decide only those points of principle for which the Court of Appeal's decision would continue to stand as authority.
My respectful invitation to the court is that you could adjourn that issue.
Yes, you've already said.
Until it's sent down, and therefore the court. Sorry to interrupt, lady, but the court could then go on and deal with the other issues.
Well, I think you've said what it is you would like us to do in respect of that issue, and it sounds as if my lords have some sympathy, as currently advised, for that course. What we did say we would do would be to resolve the points of principle which otherwise are left standing by the Court of Appeal's decision, and that is the proper approach to the gateways, query where the contract was made. That's a bit trickier, but the tort issues definitely.
Yes.
Where the damage has to be suffered,
Yes.
and if there's a distinction between fatal accidents and other claims for that purpose. So possibly in the limited time we have available, it would be sensible if you were to turn to those issues.
I'm happy to do so, Milady.
Please do so, yes.
Both Mr. Justice is dealing with the standard of proof point. Then.
Is it a standard of proof or is it a test? I'm sorry to
It's
interrupt
been-
you yet again.
It is a test, but everybody's been
But it's
calling
the
it
balance
standard
of the
proof.
argument, isn't it?
It's a balance of the argument, absolutely.
Yeah.
It
So
is.
to call that a standard of proof seems to me to be...
I may have been misled by the academics, Milady, but that's what it's tended to be called hitherto.
Anyway, the test.
The test. Can I start with the obvious point, which is both Mr. Justice Tugendhat and the Court of Appeal were satisfied that the Canada Trust Gloss test had been met in relation to both the contractual issues. I'll say no more than that. The claimant's submission is, and I'll try and summarise these before we go into the authorities, the defendant's contention that a much better argument test is inappropriate. Why? Because it's unhelpful and it should be allowed to fade away, or to use a phrase that's appeared in the academic articles and in the latest Court of Appeal decision, it should be allowed to slip from view. Secondly, we submit it's not consistent with two earlier House of Lords decisions, which is Vitkovice and Corner in 1951, and obviously in Sikonsar, which refers to that decision itself, Sikonsar being a 1994 decision. Thirdly, it would create an unnecessary and unhelpful barrier to the established common law approach to the service out of the jurisdiction issue. The correct test we submit instead is, can the claimant establish a reasonably arguable case on a jurisdictional gateway issue, or as it was referred to in Vitkovice, a strong case for argument. All of these submissions derive from the speech in Sikonsar, which is in 765 from a lady, MS 2523.
Am I the only person using modern equipment these days? 2523, did you say?
Yes, I did.
I have modern equipment, namely my brain.
Very modern.
It's volume 7, Lord, tab 65. Now, before we turn to the details of that, can I just go on and say this? All of those submissions derive from that decision. The effect of the reasonably arguable case test was explored by Mr. Justice Tier in a case called Gramsci. Gramsci's, for the note, is at Bundle 4, tab 36, MS 1699. And there is a helpful reference, cross-reference there to dicta of the then Lord Justice Toulson, where he deals in particular with the consequences when there are equally balanced arguments. It's also considered by Professor Briggs in his 2013 article, which comments on this court's decision in Abella, if I pronounce it correctly, which is at volume 10, tab 109, MS 3539. He further analysed it in a further article in 2016 at volume 10, tab 108, MS 3519, where he confirms that the test is a reasonable, arguable case, meaning, in using his terminology, a good case for argument. And finally, there is the Court of Appeal decision in Aeroflot and Berezovsky, Volume 5, Tab 46, MS 1950. Before I go to Sikonsar, the court will know that Mr. Justin Tugendhat applied the Canada Trust test. He used it as meaning a good arguable case. The test being whether the claimant has a sufficiently strong case on the issue of where the contract was made. He deals with that at paragraphs 76 to 77, and that's at MS 277. The Court of Appeal dealt with this issue in its judgment at paragraphs 17 to 24, MS 241 to 242, where Lady Justice Arden said this: when looking for the much better argument, the court is concerned with the question of relative plausibility. But there is also an absolute standard to be met. Paragraph 23, MS 242. Secondly, there must be some substance to it, since we are deciding the question of jurisdiction. The evidence must achieve an acceptable level of quality and adequacy. Also, paragraph 23. However, the standard to be attained is not that of succeeding on a balance of probabilities, because there is no trial. Paragraph 23. Lord Justice Bean agreed that the claimant had shown at least a good arguable case on both the contract points. That's paragraph 94, MS 257 to 8. Lady Justice King agreed with the judgment of Lord Justice Arden, paragraph 95, MS 258. We address this in our written case at paragraph 14, which extends over the pages MS 157 to 163. And we point out there, I can deal with it briefly, that in a case called Erdenet Mining and Bill Kenwright, two first instance decisions, both those judges appear to have followed Lady Justice Arden's approach. Erdenet is a decision of Mr. Justice Cook. It's at paragraph 13. That's in volume 4, tab 32, MS 1542 to 3. Bill Kenwright case is a decision of Mr. Justice Haddon Cave. He deals with it at paragraphs 11 to 12. That's at volume 2, tab 11, MS 952. Could I take the court now, please, to Sikonsar? So that's volume 7, tab 65, starting at MS 2523. Could I respectfully invite the court's attention to the submissions of Sidney Kentridge, QC, as he then was, which the court may find helpful. That starts at page 441 of the judgment itself. 2526 is the MS number. He refers at C to the Court of Appeal decision in Metal, which the defendants rely on heavily. If we go to F, he's dealing with the plaintiff's case on the merits. He's referring to Spiliada. Over the page at 442, paragraph C, jurisdiction requires perhaps more scrutiny than the merits. The court has to make up its mind once and for all, and so the test is higher. There must be a sufficiently cogent case to satisfy the court that it is a proper case for service out. Whether there is jurisdiction or not may be an easy question, but where, for example, there is a conflict of fact, the court seemed to want to be satisfied that there is a good arguable case, a case with a fair prospect of success. The test cannot be balance of probabilities, but the court will not have all the evidence before it, and he refers to Corner's case, which is Vitkovice and Corner. And then at E, he returns back to the merits test. Over the page at B, page 443, he's referring to the court having a wide discretion under Order 11, and that is the filter, that is the forum convenience test. Now, Lord Gough gave the leading speech. I think I can start at page 453 of the judgment, the MS number 2568.
Okay.
Prior to that, they've been dealing with the case of Vitkovice and Corner. And at C, just below C, the case was therefore in some disarray when it came from the House of Lords. This House took the view that Lord Goddard's statement, or at least Mr. Justice Slade's understanding of it, was erroneous insofar as it required that the plaintiff must satisfy the court on the civil burden of proof that his case fell within one of the heads of jurisdiction. Dealing with it's inconsistent with the standard of proof. And then just below E, equally the expression prima facie case was rejected as inappropriate because a conflict may arise on material before the court which has to reach a conclusion on all the materials before it. In an endeavour to assist on the degree of sufficiency required, Lord Simons, with whom Lord Normand agreed, said the description, a good arguable case, has been suggested by counsel for the plaintiff, and I do not quarrel with it. Lord Radcliffe, with whose statement of principle Lord Tucker agreed, used the expression a strong argument and a strong case for argument. There's no reason to suppose that there is any material difference between these various expressions from which is derived the good arguable case test, which has been applied in innumerable cases since. For present purposes, the House of Lords concluded that the good arguable test should be applied. And then the finding of this House of Lords is to be found at H on page 454, MS number 2569. As I read the paragraph, however, and having regard to the view formed in Corner's case, I'm of the opinion that what has to be sufficiently shown by the plaintiff for the purposes of establishing jurisdiction is, in the case of, for example, subparagraph 1, not merely that if the contract existed, it was made within the jurisdiction, but there was a contract, such contract was made within the jurisdiction. And then he goes on to deal with the merits. And then we can go to 456, the middle of the page, that's MS 2571.
Can be.
Just a
6, did you say?
456.
2541.
And just above paragraph D, in truth, I see it, the two elements are separate and distinct. The invocation of the principal forum convenience sings from the often expressed but anxiety that great care should be taken before bringing in court a foreigner who owes no allegiance here. But if jurisdiction is established, then it is also established that England is the forum convenes. I see no good reason why any particular degree of cogency should be required in relation to the merits of the plaintiff's case. And then right at the very bottom, he deals with the merits again at G, and just below H, accordingly, a judge faced with the question of leave to serve proceedings out of the jurisdiction will in practice have to consider both, one, whether jurisdiction has been sufficiently established on the criterion of the good arguable case laid down in Corner's case, and two, whether there's a serious issue to be tried. So there's no reference there to much the better argument. Other authorities on this, Gramsci Shipping, which is in volume 4, tab 36, MS 1699. If we go to paragraphs 29, I think that's MS 1705. There's reference to Lord Justice Waller in Canada Trust, the Bowles decision, and then I think we need to go on for the review to paragraph 45. If the Canada Trust gloss required the claimants to have the better of the argument at the interlocutory stage in all cases, then the jurisdictional challenge would succeed, but I am not persuaded that the test must be satisfied in a case where there is a stark dispute between opposing witnesses. To seek to judge who has the better of the argument on such evidence risks a pre-trial at the interlocutory stage. In order to avoid doing so, it is preferable, in my judgment, to concentrate on whether factors exist which allow the court to take jurisdiction. That will oblige the court to consider whether the evidence relied upon by the claimant has sufficient strength to allow the court to take jurisdiction. Such an approach, it seems to me, is consistent with the Canada Trust gloss. He then goes on to say this approach is supported by the following observation of Mr. Justice Toulson in Petroleum Investment, where he said, when the subject matter involves questions of fact on which evidence is incomplete or contradictory, it may be very difficult for a court to form even a preliminary view. Reading Lord Justice Waller's judgment as a whole, I do not understand him to be suggesting that in such a case the court has to be satisfied that the evidence on the claimant's side is stronger than the evidence on the defendant's side in order for the claimant to make out a good arguable case. For that would in effect be to apply the civil standard of proof, which he emphasised is not applicable at the interlocutory stage. And at 47, this approach is also consistent with the following observation of Lord Justice Toulson in WPP Holdings. There might be a case in which, because of the limitations imposed by the interlocutory process, the court found it impossible to form a positive view which side had the better argument. I would not exclude the possibility that the application of principle in the Bowles case might lead a court to conclude that if the case for jurisdiction was as good as the case against jurisdiction, and that it was not possible to reach any firmer conclusion without conducting a mini-trial, in those circumstances, factors would exist which would allow the court to take jurisdiction. Ersterbank is another first instance decision that considered this aspect of the case. The then Mr. Justice Flo, that's in the same volume at tab 34. So that's 1601, my lady. I think we can go to paragraph 13, dealing with Lord Justice Waller's Canada Trust test. And at the end of that, you can see at the top, the very end of paragraph 13, a reference to being satisfied or as satisfied as it can be, having regard to the limitations which an interlocutory process imposes, that factors exist which allow the court to take jurisdiction. For the court's note, Mr. Justice Tugendhat adopted this approach. You can see it at paragraph 75, at MS 276, on who the other contracting party was, at 89, on where the contract was made. He used the same approach, MS 280. Now, then Mr. Justice Flo then goes on and says two caveats at paragraph 14 have to be borne in mind. He refers to a decision of Lord Justice Ricks in Concola Copper Mines. If a court applying a good arguable test, he goes through it all, says, if we get to the very end of it, power to give leave to serve out of the jurisdiction is at the end of the day a discretionary one. However important, the proper disposition of a jurisdictional challenge is not something that should be allowed to subvert the merits of a potential trial. Second, although the claimant has to have the better of the argument, that is emphatically not as stringent as establishing the jurisdictional gateway threshold on the balance of probabilities, refers to a decision of Your Lordship, Lord Justice Clark, as was then the case. The correct approach to the jurisdictional gateway threshold was summarised in this way by Mr. Justice Christopher Clark in Cherney and Deripaska. I do not regard this, that is, the trust gloss, as introducing by the back door a requirement that the claimant seeking permission should prove his case on the balance of probabilities. The court is concerned at this stage with the arguments in favour of the respective parties in the light of the material then tendered. Whilst the court is entitled to reject the wholly implausible, what it will be concerned with is the relative plausibility of the contentions. Proof on the balance of probabilities would require a finding of fact, not a decision about the strength of arguments, and it would probably require the availability of oral evidence and discovery.
But Mr. Ross, all these possible tests and variations, explanations, it's all a bit arid, isn't it? Doesn't it come down to this? It was settled at the highest level that the test was a good arguable case. Lord Justice Waller in Canada Trust said that that meant that one side had a much better argument on the material available. Well, if that was wrong, or if that has been misunderstood as it were, carrying the test away from good arguable case, then we must do something about it. Very well.
I mean, all these slightly different expressions are rather bewildering, really. I mean, the idea that every time you have one of these cases you have to fish about in 18 pages of previous cases is not satisfactory.
I think that's a good hint to move on, Mr. Ross.
It is, believe me, and I shall. Could I just mention then that it's referred to by the Court of Appeal in Aeroflot, JSC Aeroflot, at Volume 5, Tab 46, MS 1950, Lord Justice Aikins saying the much better test should be allowed to slip away. He refers to that at paragraphs 48 to 50.
Well, you have mentioned that before.
And Professor Briggs's article,
You've mentioned those.
thank you, also deals with it. And I've referred to Magellan Spirit and Bill Kenwright already. So our contentions then in this regard are as simple as this. The gateways are not linchpins, as the defendants submit. We respectfully contend that the court is looking for factors which would justify allowing jurisdiction to take place. The court has, as a controlling mechanism, the forum conveniens long stop, which allows it to balance these factors and to decide whether it's an appropriate case for jurisdiction to be granted. The bar we submit should not be set so high that only a minority of cross-border claims can ever pass over the bar through the gateway. Instead, the necessary test should look at the elements of the rule as a whole, and as I've already mentioned, a good arguable case suffices for that purpose. The rules, therefore, should be relatively straightforward and easy to apply. These are sentiments echoed by Mr. Justice Tier in the case of Booth, which we'll come and look at. The case of Wink, where Mr. Justice Haddon Cave makes the same plea. And your lordships in VTB Capital made a similar observation. What one is endeavouring to ensure is that, as VTB itself confirms, avoiding these setting aside applications becoming mega trials in themselves. It was observed in that case, as your lordships know, that in an earlier age, one of their lordships had indicated that it would be appropriate for these matters to be dealt with very largely by reading in chambers and hearing short argument thereafter. Well, the higher you set the test, the bar for the jurisdictional gateway.
That was all temperate.
It was. Your lordship, I think, referred to it in your speech, your judgment. The higher the bar is set, the greater is the temptation for these jurisdictional disputes to break out and to become a real source of dispute between the parties. Where the contract was made was going to be the next topic I was going to address. This is dealt with by Mr. Justice Tugendhat at MS 266 to 7 and 277 to 280. That's paragraphs 23 to 26 of his judgment, 76 to 89 as well.
Is the issue, is there any dispute as to what the relevant test is? I mean, traditionally the test is it depends on the place where the last word in the negotiation was heard by the other party.
It's not disputed.
So the issue is entirely one of fact.
That issue is one, or as Mr. Justice Tugendhat put it, an analysis of what were the known facts before the court.
Well, now, if this is a factual issue, it may be that it is better heard with the participation of any additional parties, that your client may be advised to join.
Your Lordship knows, I do understand the point your Lordship raises. The only observation I'd make is that as the Court of Appeal made clear, and as Mr. Justice Tugendhat made clear in their respectful judgments, these defendants had taken a stance, which was that they were going to adduce no evidence, and they were going to take the point that we couldn't prove to the requisite extent our ability to pass through the gateways.
Yes.
And so this would be another opportunity that was being afforded to these particular defendants for an opportunity to have a second go at this particular issue when they've taken a stance hitherto.
I mean, you're entitled to say that you want to uphold Mr. Justice Tugendhat's finding, at least as binding as between the present parties. Okay.
My Lord, this is dealt with also by the Court of Appeal in their judgments, paragraph 64 to 70, MS 249 to 50. We weren't called upon before the Court of Appeal. The ruling is at MS 250, paragraph 69. The judge approached the issue almost as a matter of Hornbook law. There was no evidence as to foreign law, so he was bound to apply English law. The brochure was an invitation to treat. The claimant had to make an offer to book an excursion. For there to be a binding acceptance, the concierge had to accept. I reject the submission that the Canada Trust glosses as a defendant's submission can never be satisfied. At the end of the day, the trial judge might well have no direct evidence and have to draw inferences. So they dealt with it as an inference issue.
Can we just look at the inference that the judge drew?
Yes. That's back at paragraph 87, MS 280.
MS 280.
280, yes.
Forgive me.
Sorry, in paragraph?
87.
87.
Before that, he's dealt with the defendant's submission. Most probable analysis of the evidence is as follows. So he's analysing it. He's saying the brochure amounts to an advertisement or at most an invitation to treat. The claimant in the telephone conversation started informing the concierge she was interested in a shortened version of Tour 16, stating the number and ages of members of the family with whom she wished to take the tour, that she invited the concierge to put forward a proposal or proposals as to revised itinerary, timing and price. I infer the concierge did put forward one or more suggestions for a tailor-made itinerary which would enable the claimant's party to return to Cairo before rush hour in less than 16 hours after departure. I infer that the concierge probably mentioned matters not mentioned in the brochure as a requirement for a police escort. The cost was $1,000. Was to include the cost of the vehicle, driver, etc., etc. The claimant then told the concierge that she wished to make a firm booking for one of those proposed options. I take that to be the claimant's offer. I infer that the concierge accepted by saying yes, or words to the effect that she accepted the booking. And on that analysis, the contract was made in England, where the claimant heard the acceptance of the booking.
And on what was that last inference based?
That she had indicated in her witness statement that just get that out.
I mean, what the judge is inferring is that that Lady Brownlie's acceptance of the proposal was not the last word, because Lady Brownlie's acceptance of the proposal would have been heard in Egypt.
Yes, in other words, that she was being told that a booking had been made.
He's treating Lady Brownlie's expression of wish to book as an offer, he says.
Yes.
Yeah.
Accepted by the concierge, heard in England.
And therefore received in England.
Yeah.
Yes.
This is what we're prepared to do for you. Various choices. This is the one I choose. Please, will you book it? Yes, I'll book it. Heard in England.
Exactly.
That's it, isn't it?
Yes. And as your Lordship knows, without going into the highways and byways of it, the claimant was adding a whole series of personal requirements. She wanted a car for 5 people. Why? So all the family could travel together. She required the trip to take place on a Sunday. Why? Because the boys were at school. She did not want the safari to last 14 to 16 hours. Why? Too long for the children. The tour was to start at 7:30 a.m., not before dawn, again, for the purposes of the children. The safari would involve visit to local spots and a midday break for lunch. Why? The children needed to eat. The car would return to Cairo before rush hour. Why? in good time so the boys could go to school on Monday morning. It wasn't the safari tour that was being advertised, which was an all-day, 14 to 16-hour trip.
I mean, it might have happened this way, but it's no more probable that it happened the other way around. That's the problem about this rather arbitrary test, but it is the test, as you rightly accept.
Well,
Lady Brownlie's evidence, and she did give evidence on this very point, actually doesn't support this particular analysis. It doesn't contradict it. But
Where is the evidence? Can you just give us a reference to the evidence? I put compare paragraph 6 of the statement from previously, but I'm not sure where it was.
paragraph 6 and
5, MS
which is 435 and 436.
Thank you.
I mean, it's all in paragraph 6, isn't it?
Yeah.
Well, it deals with paragraph 7 indicates, this might be another pointer, that he took out a big visitor's book, opened it up and said there was the booking. So that they're making a booking.
The contract will be made before she gets to that.
Yeah, yes, of course. But it's consistent with the view that a booking was the end product. Could he provide it? Would he provide the tour excursion that she wanted, the bespoke one that she wanted? And there is confirmation. So this is where the test is of assistance. If this court is minded to follow the approach that Lord Justice Toulson was recommending in WPP, the court does not need to get concerned about which one's ahead on the argument, still less whether one's much better on the argument or not. It is whether there are factors which, if they're evenly balanced, whether there are factors exist which warrant the court accepting jurisdiction over this case. And we'd respectfully submit the one thing that she needed to be told was that the excursion had been accepted.
Well, one would have thought that the one thing that she needed to be told was what the price of the bespoke version was. And at some stage she must have said done.
Well, it doesn't follow that that was the last word on the subject. In fact,
The question is simply whether on this evidence she has discharged the burden of establishing a good arguable case that it was made in England rather than Egypt.
whether she's established a reasonably arguable case.
Yes, I mean, the burden is on her to put forward material that constitutes a good arguable case to that effect.
Indeed. But there's only one party who could have said whether her requirements were acceptable, and that would have been the concierge. There's no evidence from the other side at all to suggest this is a point that the Court of Appeal made, and we respectfully submit they were right to make it. There's no evidence from the defendants to suggest that they put forward any suggestions themselves.
Well, I mean, that's obviously right. As I understand it, what you say is the judge was entitled to come to the conclusion he did. He's made no mistake, and there's no reason to depart from it. But it could equally, I mean, it's not difficult to envisage a situation, is it, in which there's some preliminary discussion about what her requirements are. And the concierge says, well, look, what I can offer is 1, 2, 3, and 4, and the price will be X. At which the inquiring lady customer may well have said, that's all right. In which case you would have an offer and acceptance the other way around.
If one wants to speculate, your court knows that there were 2 telephone conversations. The first one happened well before, and there's no direct evidence on it. But why wasn't price mentioned then? And there's no evidence to suggest
Are you
that
talking
Lady
about the-
Brownlie asked for a discount in any way, shape or form.
Are you talking about the
I could
conversation
tell
on the
court
1st of
I've-
October?
Sorry, my lord.
Which conversation are you talking
Yes,
about, the earlier one?
the
1st of
one-
October?
Yes.
Yes, you've got the point that by the time the final conversation happened, it was the second of two.
Yes.
Yep.
That's right. So there are two conversations. Price could have mentioned one. There's no suggestion there was any negotiation of price, no suggestion that Lady Brownlie sought to achieve a discount because it wasn't a full-day tour, anything like that.
Did the brochure have the cost, did it?
No.
It didn't.
And that's, Mr. Justice Tugendhat acknowledges that and deals with it.
Well, presumably the costs would depend on Lady Brownlie's particular requirements to some
No, it
extent.
doesn't.
Might do.
Doesn't, Lord, doesn't. And there isn't evidence on this. All I can say is I've taken instructions. Doesn't follow. Respect. Anything else I should mention? Get to the third point.
Let's make a start on the third point. You've got a few minutes.
A few minutes. Yes. There are a number of things that we accept. First of all, we accept that there was...
Sorry, what is the third point?
The third point is the tort gateway, my lord. And
Well, this is the location of the damage.
And the
Defendants
exciting
have
thing
made
is
much
that
of-
it says damage rather than the damage.
it does say damage, not the damage, correct. My lady, the defendants make much of the fact that the rules of the Supreme Court, as they then were modified in 1983, in the light of the Brussels Convention 1968. Now, we accept that there was a modification, but we say there was no alignment. There wasn't alignment then, there's never been alignment since, despite the manifold opportunities that have been available to this jurisdiction to modify it so that it does align. There are a number of reasons for that, not least of which may be the decision of the Court of Appeal in Metal, which ruled that as long as some damage occurred within this jurisdiction, that sufficed. It did not have to be all of the damage. Metal is at bundle 5, tab 51, but I don't think I need to take your lordships to the court to it at this stage. However, my main point is, and this is, we rely on Professor Briggs for this in his article, which I'll take the court to after lunch. There's no credible reason to apply this line of Brussels authority, commencing with Handel's kwekerij, G.J. Beer, outside the Brussels regulation itself. More particularly because if we look at that case, it is a case about whether the place where the harmful event occurred referred both to the place where the tortious act occurred and the place where the damage occurred. And it did. So it did not answer directly the question of whether indirect or financial loss, stroke damage, falls within or without Article 5.3 of the Brussels Convention.
Well, we're talking about the amended Order 11, Rule 11F.
Yes. So it's not until, if I just finish this point, Lord, for a moment, it's not until Dumes, which is a decision in 1990, and or Marinari, which is the decision in 1995, that the European Court finally resolves the question of whether indirect or consequential financial loss is sufficient for the purposes of their jurisdictional approach. So that's the first reason why there's no alignment with the current jurisprudence of the European Court.
Is that a convenient moment?
If it is to the court, it is to me. Yes.
Well, we'll look forward to hearing from you further at 2:00.
Yes.